first case is State of Ohio versus Joshua Wilson. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve rebuttal time, please let me know, as I'll be keeping track of the time. The arguments are being recorded. When you present your argument, please introduce yourself, keep your voice up, and remain behind the podium. You should not use the names of children, minors, and victims during your argument. You can refer to them by initials or terms like the child. We have read your briefs and are ready to proceed when you are.
Thank you, Your Honor. Good morning, Your Honor. Good morning, Counsel. I'm Jeffrey Smith. I represent Mr. Joshua Wilson, who's here with us today. I will reserve 3 minutes for rebuttal, please. In regard to this case, I think that you have before you all that you need to see in terms of the video to resolve this. This is not a simple case. The first thing that appellee sets forth in his brief is that this is a simple case of a traffic citation. Well, for my client and most of my clients, nothing's ever that simple. This involves a person who has a CDL and is facing 4 points and has a business. That this is very instrumental how this turns out to him and his business and his driving record. The first thing I'd like to address is the portion about exculpatory evidence. There's a video that is part of the record that shows 22 seconds of a dash cam from a Mr. Duman who was involved in an ongoing situation with Mr. Wilson that began before the video occurred. My client expressly told the police officer who did the investigation that this started in Cuyahoga County and that it was when Mr. Duman rear-ended him in Cuyahoga County and he was trying to get Mr. Duman to pull over. It was expressly told to the police officer doing the investigation, and had he done his proper investigation at that point, this case could have been resolved a long time ago, but it was not. It was exculpatory evidence showing that my client was the victim of road rage. And he said this was a case of road rage when the police officer came to him. He had equipment in the back, a radiator that got bounced around his car, and he was the one trying to get Mr. Duman to pull over. The exculpatory evidence would have been he didn't even, if you look at page 51 of the record, he didn't even call Mr. Duman to say, hey, this is what Mr. Wilson's saying. And how incredulous is it that only 22 seconds of this dash cam is available? It's absolutely incredulous. And it's that type of thing that really ties into the fact that we have reasonable doubt about what happened.
Counsel, I would assume all those issues were discussed at the hearing at the trial for the magistrate. And so it sounds like it's a matter for cross-examination, or, because you can ask the individual, well, do you have other video? Yes. Has it been presented? No.
It was all presented.
So why doesn't that take care of it?
It doesn't take care of it because people lie. All right? He showed up and who knows what he did, but it would take the police to get the video and get the dash cam and to review it to see what had happened beforehand.
Why would it take the police to get that video? Couldn't that have been accomplished by a subpoena from the defense?
We asked for preservation, but the problem is this is...
How do you preserve something that isn't in your possession?
Well, when it comes to the defense getting that, it would have been inconsequential if it wasn't taken care of immediately when the accident occurred. The accident occurred, he was contacted, and he told him his side of the story and said there's more to this story than what you're seeing. And he could not have possibly, under Rule 17 or anything else, gone to this Mr. DeMott's house on the day that this accident occurred and get that video or get that dash cam. Only the police could have got it with a warrant at that particular time. That's
So at that particular time, within the days that it gets erased, or
right.
there couldn't have been a subpoena by his attorney? Because, traffic cases go fairly quickly. I mean, the speedy traffic for traffic is 30 days for minor misdemeanors.
Right, this was in the North Regional Mayor's Court, and he gets a summons to go to court, but we're talking about the fact that this investigation had the opportunity to get a warrant to find exculpatory evidence in my client's favor, and it was not done, and the police officer, even in the transcript, showed no desire to even call Mr. Dumont and ask him about my client's side of the story and what happened, nor to get the dash cam. And the dash cam was right there. He showed him the dash cam and said, well, there's only 22 seconds. Common sense, folks. Common sense says, well, how about you give us the dash cam and we take a look at it? And then after my client talks to him, common sense says, well, we better get this dash cam before he pulls a Tom Brady on it. And like the Inflategate, he takes his cell phone and destroys it so nobody can find his text messages. That's what we're talking. We're talking about police doing their work, finding exculpatory evidence, and it was a series of events.
The problem is, counsel, isn't it, that there is no way of knowing this was exculpatory? You can't really present to the court that it was exculpatory because you've not reviewed it either.
I'm sorry, I missed the
There's no way of knowing this was exculpatory, so there's nothing in the record for us to be able to say the police didn't, or the prosecutor didn't turn over exculpatory evidence, which is what their standard would have to be. They'd have to be in their possession, and it'd have to be shown that it's exculpatory.
Well, the fact that it's out there and it's possibly existing, had they got it and done their job, we would know whether it's exculpatory or not. I am 100% sure that it is, because it's gonna show him rear-ended Mr. Wilson on 480 somewhere in Fairview or North Homestead.
Was there evidence presented to damage to his car at the trial?
I don't think that there was any damage to his car,
He was rear-ended without damage, you're saying?
Yeah, he was going along, kind of like a NASCAR where they come up and bump the cars to move them out of the way.
Are you sure video ever existed? Because
Yes.
some of these video systems operate on certain.
Yeah, I'm sure that it's there. I'm sure that it was there. I'm sure.
How are you sure? Was there something at the lower level where they said it existed and then it was erased, or?
Well, he said that there was video after the accident that he just felt, in fact, the record says he felt it was irrelevant to produce it to the police. How is Mr. DeMott the one to decide what's relevant or irrelevant? And that's why we're here in front of him. And now if we could just go to the actual video that we do have, it shows the blinker on, Mr. Wilson trying to pull up to him, and Mr. DeMott, as he had in the past, pulling up, speeding up his car to close off the gap, causing Mr. Wilson's car to weave. That goes to, who actually was the cause of this. He had room to get there, but if we see from the video itself that he sped up, we know he sped up. He sped up and clipped my client's back corner of his car. And now my client's had enough of this and moves on. And I think that shows who's involved in this accident. And you can see clearly on the video that the blinker's on, which is what he was charged with, not having his blinker on the other count. I think if you take a look at all of this evidence, that you'll be quite confident that the lower court did not view this evidence in terms of what's reasonable doubt and viewed it in some other standard. Because reasonable doubt is very clear that my client had come up to him, was passing him on the right, which you're allowed to do, put his blinker on, and Mr. DeMott decided to speed up his car and clip the back of my client's car. Okay, thank you,
You'll have your full 5 minutes for rebuttal.
thank you.
Thank you, Your Honor. Your Honors, may it please the court, my name is Sean Keller, and I represent the appellee, City of North Ridgeville. I'm gonna try not to read, but I know you didn't want me to read my brief, and so I made some notes, and then my limited eyesight has caused me trouble here. You know, I know the court's familiar with the briefs, and what my esteemed opponent here, Mr. Smith, recites to you as the facts. I do not have a familiarity with those facts, and I was up deep into the night last night. I watched the video of the 24-second video. I watched the trial again in its entirety. I saw the interview with the defendant, now appellant, and I do not see where it was alleged in trial by the appellant that he was at any time struck by the Mr. Dumont, the victim in this case, before he did his quite dangerous traffic maneuver inside the city of North Ridgeville and really earned the reckless operation charge, Your Honor. It was such that it could have been dangerous to Mr. Dumont, the appellant, and any motorist that was on the road that day, because they lost control of their car for a brief second or two at the point of impact, and that was a very crowded rush hour time on 480 where it breaks to 20 and 10. This is an important case, and I know that all of them that you accept are important in their own way, but no one here is denied their liberty. If this is not, after watching the video, a matter of reckless operation, then I'm not sure what qualifies to be charged with reckless operation. The ramifications for the defendant may be serious as a small business owner and owner of a CDL, but that doesn't excuse him to go and drive in that manner. And this whole thing has been investigated by the police. It's gone through our pretrial process. It went through 3 pretrials at a mayor's court. It went over to the magistrate. It had pretrials at the magistrate. The evidence that we had, that we owned, we supplied. We had probably a 2-hour trial on this, where everything was reviewed. And then appellant, through his counsel, objected to the decision of the magistrate, retired Judge Bilancini, and the judge assigned, Judge White. He watched the whole thing in its entirety. He watched the entire trial. He watched the 24 seconds of video. He watched the VOD. He watched the interview, and he found that the defendant, at that time the defendant, now appellant, was simply just not credible. He said that after a complete review of the trial record, the defendant's testimony that he believed he was somewhat safe to move over, that I did not know I hit him, and that it was the victim who sped up and caused the impact, is inconsistent and simply not credible. This is an argument about some video.
Well, the other driver did admit at trial that he sped up, though.
He did, Your Honor.
And evidently that was not relayed to the police officer at the time.
It was not relayed to the police officer, but it was, and he explained why in cross-examination from Mr. Smith, I believe, is that he has in the dash cam in the lower right corner, it shows his speed. There were 2 trucks in front of the 2 parties, Mr. Dumont in the high-speed lane and the appellant in the center lane to Mr. DeMond's right, which should be technically the slower lane. You can see that, and the testimony was that the appellant was riding along next to him, yelling, sticking his head out the window, shaking his fist. And then you also see the big truck in front of the victim, Mr. Dumont, start to move and cause separation between him and the truck that he was traveling next to. That quite frankly is Mr. Dumont's ability, that's his opportunity to move forward and get away from this guy who's traveling next to him. And that is also, he starts to move to follow and speed up. And that's when you see, and you can see in the shadow on the video, you can see the appellant's vehicle shadowing Mr. Dumont, and then you see the appellant really accelerate and cut in front of, rather violently cut in front of the victim, Mr. Dumont, and cause both of their vehicles to go out of control for a brief moment. They were surrounded by other vehicles. This could have been a deadly miscalculation on appellant's part as a result of him being angry. So it was.
I wasn't quite understanding about the berm, how that was,
Yeah.
came into play.
Thank you, Your Honor. It was elicited through the trial and through the investigation that the victim, Mr. Dumont, had been traveling in companionship with the appellant. The appellant was ahead of him as they were going down 480 over by, I think, Great Northern, if you're familiar with that section of 480. They were behind the appellant, and he was in the high-speed lane, but he was traveling slower or in tandem with the other vehicles. He wasn't passing, and as a result, at that time of day, Mr. Dumont was stuck behind him with no place to go, and there was traffic. Their testimony is that there was a lot of traffic backed up behind Mr. Dumont. Essentially, the appellant was clogging things up. When the appellant appeared to move to the right so that Mr. Dumont and all of those other travelers behind him could then move forward faster in the high-speed lane, in the passing lane, he starts to move into the area that he thought was vacated. He moves partially in, and the appellant decides to move back, forcing Mr. Dumont to finish the pass with partially on the left berm, with the left side of his vehicle. So he didn't zoom up and drive around him on the berm. He admitted, and he rather sheepishly admitted, that he inadvisedly didn't wait for the defendant to get all the way out of the lane before he started to move up, and that was the way that he could, Mr. Dumont could avoid the accident. And he did, in fact, complete the pass, and that is how the appellant ended up behind him, and then eventually moved over and got up next to him so he could shadow him.
And the other driver wasn't cited?
No, ma'am. And that event, as described by the victim, I probably wouldn't have cited even if I could, but that occurred outside the city of North Ridgeville, outside my jurisdiction, outside the county. It was because where it eventually ended was just inside North Ridgeville, and that's how I know.
I was just wondering, because to try to pass somebody before they moved into the other lane is a little reckless as well.
It could be reckless, and I will tell you that the victim admitted it on the stand. He said, that was my mistake. I shouldn't have done that. I should have waited. His testimony was both credible and sympathetic. There's even when you see him struggling with trying to retrieve the video for the officer, he's so frustrated with this new gadget that he's paid for. He actually says, boy, I wish I'd sprung for a better camera. And so he was a sympathetic and a good, credible witness. He admitted the things that he did wrong, but he was a victim in this case. This is an unusual case because it's not spoilage of evidence, or it's not the standard case about evidence under state's control that the state did not take care to preserve. This is not a case with booking room videos or dash cam or body cams. This is a private citizen who bought a dash cam for pretty much precisely this purpose, is to protect himself while he's out on the road, and he just doesn't know how to use it. But if you gave me a test on how to use my phone that's been in my pocket for 2 years, I probably wouldn't be able to explain a lot of the apps on it and the things and the functions, you know. So, and he was very credible, and he explained how he couldn't retrieve or how he understood the dash cam to have a small memory and that it would write over itself. So he couldn't supply prior video, and he didn't think to supply later video. And he actually said, I didn't think it was relevant. And I have to say, I don't think it was relevant either. The particular act for which the appellant was cited is caught on video, and it's the first time that anyone alleges that there was a crash, a touching of the two vehicles. That was not brought up in trial by the appellant. So the defendant always have the ability to point to the empty chair, and they are protected by beyond reasonable doubt. And so it's a tough standard, and they can always say, if we had this video, this whole thing would be different, and they did. So they exercised that muscle at trial ad nauseum. The defense counsel really pounded that this cross-examined the officer, about not getting more video, cross-examined the victim, Mr. Dumont, about not supplying more video. He used that. He pointed to the empty chair, and still 2 seasoned judiciary found that the defendant's appellant's story was not credible, and they're in the best position to weigh the credibility of the witnesses. I don't want to prolong this, but subject to your questions, I would just say that this was justly determined through 2 different lenses. The totality of the circumstances that were brought forth at the 2-hour trial, all the testimony, all the video, the interviews, and then you of course have the transcripts. It was rightly decided, so I would ask that the appellant's appeal be denied.
And you'll have your full 5 minutes.
Thank you, Your Honor. What I would indicate to the court is that the deadly miscalculation was by Mr. Dumont.
I couldn't hear that.
Well, it was the deadly miscalculation was by Mr. Dumont. when he saw my client trying to get him to pull over. By the way, his window doesn't go on, so he couldn't have been, doesn't go down, and that's in the record. He was telling him to pull over. He saw him to move up, and Mr. Dumont is the one who sped up to try and keep my client from getting in front of him. He still managed to get in front of him even though he sped up.
Is it reckless to chase somebody down and try to get them to pull over your car? Because wouldn't the proper thing be to get hit skip and you would call police and make a report?
I think the proper thing to do is to try and get him to pull over.
I mean, if you're doing it with your car.
Well, you're driving saying pull over because something happened. I mean, he's not waving to him because something didn't happen. I mean, that's clear I would think anybody who sees and hears what's going on, even Mr. Dumont says, hey, he's waving at me for some reason. It's because he wants him to pull over. And then he goes forward to pull in front of him, and Mr. Dumont, as you can see on the video, speeds up and causes a collision. My client's the victim here.
So you think the video contradicts the testimony? So we watched the
Of
video.
Mr. Dumont.
Okay.
I think for sure it does. For sure it does. And the fact that we got 22 seconds of video on this dash cam, to me, is also just, is beyond me. That, you know, that's all that he would show them. And that he would only tell the police. He didn't tell the police about anything that happened beforehand. He just said, hey, look at what this guy did.
Well, what, maybe following up a little bit on Judge Hensel's question, why would that be relevant? Why would it be relevant, even if he had hit him or he had done whatever to him? Let's say that's true, the other driver. You don't have the right to self-help on an interstate.
I would agree with that, but so if it's not relevant, why wouldn't he tell him? He didn't
But
tell
I'm
him.
saying for us, why is it relevant?
It's
Because-
relevant because my client was the one who was trying to avoid this situation. My client was the one who got the first impact.
All you have to do is slow down and let the person go around you.
Well, but he had a radiator that he thought got damaged that flew around in the back of his trunk, and the guy passed him on the berm, and because he wasn't happy, and in that area, I don't know if you folks know that or not, but it's a very much of a speed, people get a lot of speeding tickets in that area on 480. It's very, you gotta be really careful driving on that, which he was doing. He was driving along in the fast lane at the most you could go without getting a ticket. And Mr. Dumont's the one who caused this whole issue to happen, and then he caused it again. Then he caused it again when he sped up and hit my client while he was trying to get in front of him. I think it is pretty clear what that video shows. It confirms what my client's side of the story is when you take a look at everything. And the fact that the North Ridgeville Police, when I asked them the questions on page 51, did you do this? No. Did you do that? No. Did you do this? Everything that would have been exculpatory, everything would have been exculpatory to my client if they had followed through on that. I thank you all for your time and attention in this, and appreciate your time. Thank you.
The court will take this matter under advisement and issue a ruling in due course. The clerk of courts will mail you a copy of the decision on the day it's released, and also the opinions are available on the Ohio Supreme Court website. Thank you both for your presentations.
Thank you, Your Honor.
Thank you.